Welcome back. You know that old saying, the Constitution's a living document? Well, U.S. Supreme Court Justice Antonin Scalia, he doesn't agree. In fact, he emphatically disagrees. During a lecture at SMU this week, he said, quote, "It's not a living document. It's dead, dead, dead," 3 times just to make sure everybody got the point. He said the judge always likes the results he reaches, is a bad judge. Now, Scalia went on to tell the crowd that sometimes the decisions that he arrives at are not in concert with his political convictions. What does this mean for future rulings? And just clear up for me that the Constitution is dead, dead, dead. What was your takeaway there?
Well, this is nothing to see here. People move along. And this is Scalia being Scalia. He's an unabashed originalist, a guy who construes the text of the Constitution very, very literally. And this is page 101 from the Scalia playbook. So there's really nothing to take away. You know, there's a school of constitutional thought that says the Constitution is a living, breathing document that changes over time. And Scalia says, well...
But didn't he just say that as it relates to the Second Amendment? Didn't he just say that there is an interpretation that societies have to make here as to what is in effect for them, the right limits or freedoms as it relates to, in this case, gun ownership? How is that not a living thing?
Well, he's delving back into the history of the Constitution at the time of the founding to divine what he perceives to be the original intent of the framers. So, you know, Scalia will get into politics in his decision-making also, no doubt about it. But he's actually more ideologically consistent and less result-driven than almost any other member of the Supreme Court. And I'll give you a couple of examples about it. This is a guy who personally hates criminals and is very tough on crime. But he has expanded defendants' rights consistently over the past decade in the areas of, for example, cross-examination and criminal sentencing, even though that goes against the grain of what he believes at his very core. Now, on the other hand, regarding, say, Miranda, the exclusionary rule, and the Fourth Amendment right against unreasonable searches and seizures, these he construes very narrowly because he reads the Fourth and Fifth Amendments more narrowly than he does the Sixth.
Let me ask you, you've testified, I'm sorry, you've been before the High Court, you've tried. Do you prefer, it's almost like any kind of judge in any kind of endeavor with, that you know his strike zone in effect? Do you prefer to know the justice's strike zone in that he's a strict constructionist, letter of the law, or would you rather have somebody who has some interpretation and views it as a living document?
Well, it depends on the case. As a criminal defense lawyer, more often than not, I want somebody like Justice Breyer who will be more of a pragmatist and have a little bit more play in the joints. It depends on the issue. If I'm arguing, for example, a Sixth Amendment issue, I want Scalia, who's not going to let the facts of the case, however ugly they may be, prevent him from coming down on my side.
We're using words and phrases, I think, imprecisely, and I think that's something lawyers shouldn't do. The choice is not between a strict constructionist and it's an original intentist, which is a different thing. He's saying, Scalia, that the...
What's the difference?
Well, he believes that the intent is embodied in the words.
How about this? What's the intent of the prohibition against unreasonable search and seizure when it comes to a spike mic or remote sensing? The founders had no opinion about that. You can't go back to their original intent and figure out what they would do.
Well, you can, because according to him, because he would read the text as people have a right to be secure in their persons, personal effects, and homes. And so the spike mic would infringe, theoretically, on the integrity of the person.
But the question of what constitutes secure, which is the word you used, is a question of interpretation. He engages in it all the time.
He does.
They are not consistently that way. He is, in my judgment, with a few exceptions of the kind you pointed out, result-oriented. Look at Gore.
Well, what about the flag
Bush.
burning opinion?
No one is wrong all the time.
No, but I mean, he hates flag burning, and he said you have a right to do it.
You know, he stumbled on it. Good for him. But as a consistent model of judicial analysis, there's not much there that stands a lot of scrutiny.
I'm confused.
Everybody does it.
I'm confused by something.
Yeah.
If the framers set up the Constitution intentionally to be amended and amendable because they said we don't know everything,
right.
And then they also set up a Supreme Court to interpret the Constitution and the application.
That's the argument. There's nothing in the text of the Constitution
the amendment
that
leaves
gives
it to the political branches to do and the will of the people. Once that's set in stone, then if there's an ambiguity in the document, it falls to the
One side would
judiciary.
argue
to
they
interpret.
put the Supreme
The
Court there
const-
to uphold the
The
Constitution,
Constitution does not give the Supreme Court explicit power to review statutes for the purpose of declaring their constitutionality.
That was Marbury?
There were a set of cases that came at the end of the 18th century that sort of dealt with this. But even that's a matter of interpretation. If Scalia was an original intentist, in practical form, he could argue that the Supreme Court, and he has occasionally, has no right to overturn a statute that the legislative branch has enacted.
He does. At
Every
times
once in
make
a
that
while he
argument.
mumbles.
I just don't see how if the framers said this thing is fungible, this thing can be.
It's not, but it's not easy to amend the Constitution, and it leaves the responsibility for that with the body politic. Which
Mark,
is
I
where
give
it should
myself,
be.
I didn't get to ask you. Cases either that they got on the docket here or some issues you see coming down the pike in this second term of Obama here, the people I keep an eye on.
Well, obviously, the big ones, the same-sex marriage. We have the
That's an
affirmative.
inevitability, you think?
I don't know if it's an inevitability now. I think that it will incrementally go in that direction. I don't think it's an inevitability at all. We've got the voting rights cases coming.
Inevitability,
Eventually.
they're going to decide it one way or the other?
Oh, they've already taken it.
Oh, it's scheduled for argument at the end of March, but I don't think for a moment that they're
They'll-
going to
they'll leave
declare
it to
some
the states.
broad right
Look
to
at the
same-sex
cases
marriage.
on reproductive, whether Obamacare has to, can constitutionally require a religious
control.
organization which owns
Yes.
a non-religious institution to provide all kinds of services to its employees.
And we're waiting on the affirmative action decision, which is a huge one. As well.
Finally, Andrew, I want to give him credit. Mentioned this yesterday. We talked a lot about Hillary and Obama. His bet is that all this is angling because she wants a spot on the high court.
Or he might want to put her there.
They talked about that before she was given Secretary of State. I mean, it wouldn't be the first time that a judicial novice got that job. We look back at Earl Warren, but this is an era of a professional judiciary, and it would be highly irregular but not unprecedented if that would happen now.
We jump to a quick break. When we come back, we're going to talk sports. Usually in the run-up to the Super Bowl, we're all talking about fun and games here, but unfortunately, yet again, same story over and over again. Big sports star, you pick the sport, it almost doesn't matter anymore, caught allegedly using performance-enhancing drugs. I know you're exhausted by the story here, but I think that's part of the conversation. Stay with us.